Hello, how are you doing? You're welcome to Lawyers Info Hub. It's always a pleasure to have you on this platform. I thank all my returning subscribers for their consistency in following this page. I thank you, my new subscribers. Yes, because I know that after watching this video, you will want to subscribe to join this great family. This is Lawyers Info Hub, a platform where we teach law concepts, we simplify legal concepts, we share experiences that will help you become better in your practice as a lawyer. We'll, you will use our own experience to bring to you, insights that will help you. We invite other people to share their legal experiences aimed at helping you become the best you can ever be in your career, in your pursuit, even in personal development. So today we're looking at eviction. We're looking at recovery of premises. This is one aspect a lot of people have always had issues, and the real estate. Let me just put it this way: the real estate sector is very deep, and recovery of premises is just one aspect of it. Recovery of premises, you know, is is a niche, or is a legal process that, if you don't really know how to get it right, you might mess it up, even when you are right, even when the tenant is in arrears of rent, even when you have all it takes. But if you don't follow the procedure, you might mess it up, and at the end of the day, you start all over again, and you are the one to bear the burden, the liability, and the cost. Now you want to eject a client, a tenant. Sorry, a tenant, not a client here. You want to eject a tenant. The tenant is owing, or the tenant may not be owing, but the tenant has breached the tenancy agreement, the lease agreement, um, and all efforts to make the tenant, you know, to stop the breach has proved abortive. We have two statutory notices that you're supposed to serve. We have the first one, which is a quit notice. I know in serving a quit notice, the length of notice is dependent on the tenancy duration. These are fundamentals. I have a video on this channel on recovery of premises. On this, I've list, on these fundamentals, the basics. So today we're just focusing on, after you've gotten judgment, how do you now evict the tenant? So you can check the channel on this other part one of the video, wherein I've talked about the basics on issuance of quit notice, how to even draft a quit notice. We have all of those in this channel. So after you have issued the statutory notice, quit notice, 7 days notice, or notice we call the notice of owner's intention to recover possession, and the tenant has still failed to move out of the premises, then you can now go to court by filing your summons for recovery of premises, depending on your jurisdiction. I've seen where a plant is used. I've seen where, you know, like the form tier 4 is used, for summons for recovery, depending on where you are and how it's being drafted in your jurisdiction. But similarly, this is the same structure content wise. So you file your processes. In this your process, you need to state, have what we have like call the statement of claim, depending on what you're using. This is now where you state the story, state when the tenant moved into the house. You state if he's in arrears or he has breached the tenancy terms. You state effort you have made, maybe letters you wrote. Peradventure the tenant is owing, you state the letters, final reminder letters or reminder letters sent to the tenant to pay, and the tenant refused to pay. You also have to attach and evidence, show the statutory notices that was served on the tenant. Now, you now also state what the tenant is owing, your mean profit. If you're asking for cost of suit, beautiful. You have to also state the grounds upon which you're bringing up your summons. For it could be for personal, you want to vacant possession for personal reasons, renovation, whatever it is you put in your ground. Then you have a witness statement of oath that's accompanying your originating process. Then your list of witness. Peradventure, sometimes the owner of the property may not be in that jurisdiction or even within the country. A power of attorney can be donated for someone to represent the owner of the property. Now, when you are suing, you must also note, or on the face of the process, there has to be the designation under the claimant that this person is suing through his lawful attorney. You state the name of the owner of the property, who is the landlord or the landlady, suing through his attorney. You put the name of the attorney. Now, the witness can also be the attorney who will depose the witness statement on oath, and all of that. Now, in court, in a jurisdiction that there are no more much cases, or in a jurisdiction where the judiciary is very fast, a tenancy matter should not last more than 3 adjournments. I've even seen where in 2 adjournments the whole thing can on. But you've also seen where in 2 years a tenancy case can still be going on if it is contested, where the defendant is filing one objection or the other, preliminary objection here and there. Sometimes they even appeal rulings of court. Like a normal civil matter, the once the court has confirmed that you have served the tenant. Now, in most cases, most of the tenants always evade service. So what most lawyers will do is, after the first attempt by the sheriff of the court, and it's not personal service is not possible, then you file a motion for substituted service. And when you file a motion for substituted service, you get the order of the court and give it to the bailiff or the sheriff of the court, who attaches it with the originating processes and go and file. It's very important that you don't miss this step at the beginning of the hearing of your matter. Service is very key, because we've seen issues where the issue of service has truncated the hearing of the substantive suit. So ensure the tenant is well served, either personally or by substituted means. After which, the court will now give a date for trial. The trial, the claimant, who's the owner of the property, or the attorney will give evidence. If there's representation from the other side, beautiful, is cross-examined. If there is not, the court will still give another opportunity for them to come and cross-examine, after which, if they fail to appear, the court will foreclose them from either cross-examining the claimant or even giving their evidence. Now, we have also seen, while in court, where parties, the claimant and the defendant, comes together and try to settle by, maybe the tenant is saying, okay, give me 3 months, give me 1 month, give me 6 months, or the defendant, or with the tenant, comes with his lawyer to say, we want to settle this. This is the tenant's matter. It is true my client is owing. We're not denying the fact that my client is we're not denying the fact that my client is we're not denying the fact that my client is owing, but can we give us time for my client to look for an alternative accommodation? It's usually the case, but most times it's not also the case. In that instance, the court will say, okay, go and put your hands together, put up the terms, sign, and come, I'll enter it as consent judgment. Now, let's also remember that even if when parties come together and agree, put their terms together, and the court enters that the agreement as consent judgment, if the tenant or who's the defendant at the end of the time given fails to honor that agreement, the claimant can still proceed to evict him. Now, but when issue of there was no terms and all of that, judgment is not given, what should the lawyer do? What the lawyer should do, first of all, you apply for the certified true copy of the judgment. When you get the judgment of the court that gave that judgment, the judgment of the court in its judgment will state what the defendant is owing, when the defendant is supposed to vacate the premises. Now, when you get the judgment of the court, you go to the sheriff session or the bailiff session in your jurisdiction. When you go there, you meet any of the bailiff of your choice, depending on how it is done in your jurisdiction. But basically, you can meet the bailiff, or sometimes you meet the chief bailiff, who will ask, okay, I will assign it to this particular bailiff. Or if you have the bailiff who you have been working with, there are bailiffs that are into execution, there are bailiffs that are just service bailiffs. But who you are going to meet is the bailiffs that are in execution. Not all bailiffs can execute judgment. So it's the bailiffs that are in execution session that you meet, you give them the judgment. Okay, what they do is that when they read the judgment, they'll ask for the details of the court, because sometimes where the bailiffs are, maybe those that do execution may be different from where the court is situated. So they will ask for the details of the court, and they will go to the court and request for the file When they go to court and request for the file will be given to them, though there is an administrative process before the file can be released to the sheriff. The file have to be moved back to the archive because judgment have been given from the archive, depending on what is on ground, but there is always an administrative process to go through before the bailiff can move that file. Some other time, the bailiff may not be given the file in hand. The administrative officer, or depending on the administrative hierarchy or structure in place, will have to take the file by themselves to the bailiff section, wherever, maybe in the, depending on where it is situated. They will now record that the bailiff section has received this file, and the bailiff in question will be notified that the file came in, or the, for you. So when the file comes in, the bailiff, who is well trained in this, will look through the file to confirm that this judgment was from the court and all of that. Look at the court proceedings and all of that. After which, you will liaise with the chief bailiff, and they will issue a letter to the police, because a police officer usually accompany them for the eviction. When they issue a letter to the police, that they want backup or want police officers follow them for execution. The police will revert back to them by responding to that correspondence to confirm to the chief bailiff, please confirm that this judgment emanated from so court, and that this is a genuine judgment, not a fake judgment, because a lot of people can, procure fake judgment. So when the police reverse back to, response to their correspondence, they will also write to say, we confirm that this judgment is genuine. The chief bailiff will confirm and sign that, I confirm that this judgment is genuine, emanating from so court. Please accede to our request. After some administrative process again, the police will confirm that they will be willing to release their men to accompany them, to accompany them, for the eviction. Payments are also done, yes, but it's the bailiff that sorts that out, not the lawyer. Sometimes they'll tell you to fast track the correspondence because a lot of back and forth. After that, now the chief magistrate, for example, if it's a magistrate court, which is most likely, the chief magistrate of that division has to sign the warrant of possession. Now, the file will also be taken to the chief magistrate. Most times in most jurisdictions, what happens is that once the bailiff requests for the file will be moved to the chief magistrate first. Some other time, it will move to the bailiff session, the chief bailiff, who confirms all these other things I've earlier stated. But before you get the warrant of possession, the chief bailiff in charge of that judicial division will have to look at the file. The office of the chief magistrate will have to look at the file and confirm that everything is in order. Why this is done is to avoid issue of where someone will go and concoct a judgment and go and evict a tenant who's arbitrarily. So all these processes are taken to ensure that the process is done well, and the fact that maybe the tenant, was given an option to appear in court, he didn't appear, and indeed that the tenant is owing, and that whatever the claimant is claiming is right. So the chief magistrate will now sign the warrant of possession and send the file to the bailiff session again. This is now when the bailiff is now empowered to go and carry out what the judgment of the court, which is what, to recover possession of that house, or recovery of premises, as we call it. Now, whenever the bailiff will now have to liaise with the police. It's okay, this is the date that is convenient for me. Based on your correspondence, are going to allow us go with your men. We're going on a Tuesday, or we're going on a Monday, or going on a Wednesday. So the bailiff and the police will now liaise together on the possible date. Now, on the part of a lawyer, what will the lawyer, part of the things the lawyer is supposed to do? One, the lawyer must be able to know the tenant in terms of, is he a tenant that is always around? Because most times when they go to do this eviction and the house is locked and nobody is there, they will tell you they cannot force the door open until you get an order for force open. This is another process. So as a lawyer, you must be sure that this tenant is always around, like somebody in the house, you know. And is it someone that leaves very early? Is it someone that maybe is around only on weekends? This is something the lawyer has to do. This is what we call due diligence. The lawyer will have to do this. Then confirm the availability of that tenant to know that when we go there, someone will be there. Also, it's also very important to note that if you are to get order for force open, you're sure that this tenant is not there. Is after the judgment has been given, you can bring an application to the same court to tell the court that by information you have, or you have visited the place to know that they told you that the tenant has not been available for maybe 6 months and locked the apartment. So the magistrate will make another order for force open, which will help the other judge. It will be, yes, kind of kind of a ruling, because you have to file your application by motion, granting your request to force open the apartment. Because if there is no order for force open, many believe, yes, I said they will not want to open that house without the order for force open. Now, on the day of the eviction, most times, evictions happen early in the morning when you can meet the people at home. Because sometimes you can come in the day, nobody's at home, they have moved out. So when they get to the place they're going to, the apartment, you have to identify the flat or the property, they will knock. When they knock, if anybody that comes up or comes out of the house, they have to identify the person. Please, who are you? Are you Mr. So, the name of the person on the judgment, on the warrant too? Are you Mr. So? No, I'm the brother or something. Okay, we want to see Mr. So or Mrs. depending. When the person comes, they will introduce, the bailiff of the court will introduce himself. I'm so person, sheriff of the court. I am from so division. You introduce the police people with him, and whoever with him, maybe his colleagues or whoever, those assisting the sheriff will be introduced. Okay, that's the judgment of the court against you over this house. We have come to recover this house based on the judgment of the court, and they will serve him a copy of the warrant. The defendant will be served a copy of the warrant. Sometimes they will look at it, sometimes they will not look at it. But if a tenant who knows he or she is owing, will always know that the time is up. They will ask the person to please go inside, take care of your personal effects, gather your. I'll give you I'll give you some time for you to go in and gather your personal effect. Why this is done is that so that the person will not come and say, "You my money. Well, I left my money on the table. My ATM card here, my bag here." So the defender is given time to go in and gather their personal effect, so that the issue of mixing things will not come up. Then the sheriff and his people will move in and to remove the properties of the defendant from that house. Now, in some jurisdiction where there is space, where there's a lot of space, the belongings or the properties that was, will be as that is attached will be taken to the court, wherein at a later date an auction will be made and the property will be sold and all of that. That is another process altogether. But sometimes in some jurisdiction, there is no space in the court where people's property will even be kept. So some other time they will tell you, we cannot attach the property. Right from the onset, we cannot attach. But if you want us to attach, you might say, okay, you make an undertaking that you will take this property to your own place. The court will take the inventory, but you take it to your own place for safety and to safeguard it. Whenever the court will do auction, you bring it to the court for auction so that you can recover your money or whatsoever. But in some other place, they'll tell you, we don't have space, we're not going to attach. What we're going to give you just to recover the vacant possession of the apartment or the property. So if they are not attaching, when they remove all the property from the building outside, they will lock the place and hand over the lawyer key to the lawyer or whoever is representing the lawyer. Then the warrant will be signed by both the claimant representative and the defendant to say this is what was removed and that we have complied with the order of court dated so and so. So this is just a summary of what happens if you want to evict. It takes a while. Let us not forget also that in the process of you trying to evict a tenant, the tenant or the defendant can also file a motion for leave to appeal the judgment of that court. And when there is a motion, the bailiff cannot proceed for the eviction until that motion is determined. So this is what most defendants do to buy time. So you must also file your counter. The court will hear the motion again, whether they can grant them leave and all of that before, until all applications are what dispensed with, the bailiff of the court or the sheriff cannot proceed to evict a tenant. So these are many more are the steps that happens, or the process that you go through when you are evicting a tenant under recovery of premises. I just hope you've been able to learn something. If you have further questions, drop them as a comment for me. I will answer it. I thank you all for who have been coming back to the channel to check. We have so many contents that are very valuable, that will help you in your career, that will help you so much. Check through our channel, you see a lot of them, and you'll be glad that you did. If you're yet to subscribe, please do hit the subscribe button, share the video, and you know what? You'll be glad that you're part of this great family. Thank you, and do stay safe.